look after, and I would suggest strongly that we should be looking after C-14 right now, and we have to support the motion presented by my colleague, Mr. Brock, and we have to move forward on that one.
Relevance again.
Mr. Chang.
Relevance.
I agree. Mr. Gill, you're still not talking about this bill or more specifically this amendment.
Mr. Chair, if that is the case, then I'll cede my time and then move on. But actually, we should not be stopping anyone to speak when we are talking about the important legislation that need to be discussed at this committee meeting.
Thank you, Mr. Gill. Okay, any other further submissions on Mr. Fortin's proposed amendment? No? Okay, so before we put it to a vote, let me just remind you what I said at the outset. If BQ2 is adopted, Lib 1, CPC 6, and CPC 7 cannot be moved due to a line conflict. Okay, so we'll put it to a vote now.
Yes. On amendment BQ2, I will go with Madame Latenzio.
No.
Monsieur Osfather.
No.
Madame Dillon. Monsieur Chang.
No.
Mr. Brock.
No.
Mr. Lawton.
No.
Mr. Baber.
No.
Mr. Gill.
No.
Monsieur Fortin.
Oui.
Defeated 1-9.
All right, amendment defeated. Thank you. Okay, so now moving on to
Lib 1.
Lib 1. So I will give the floor to Mr. Housefather.
Chair, this is a simple amendment. The Hindu communities and some other communities, the Jain community, view the swastika as a holy symbol in their culture. We can refer to the Nazi Hakenkreuz, which is the symbol that used by the Nazis without using the word swastika in the English version of the bill. And so my amendment, all it does is remove the word swastika from the English version of the bill. And I hope that this is something that we can all agree on, given the community's representations. Thank you, Mr. Chair.
Thank you, Mr. Housefather. Any other submissions on that? No? Okay, so we'll move on to vote on Lib Amendment 1.
Okay. On the vote.
On the vote.
Madame Latenzio.
In favor?
Monsieur Osfather.
In favor?
Madame Dillon.
Oui.
Monsieur Chang.
Yes.
Mr. Brock.
Yes.
Mr. Baber.
Yes.
Mr. Lawton.
Yes.
Mr. Gill.
Yes.
Mr. Fortin. Unanimous.
Carried.
Yeah, unanimous.
Okay, amendment carried, which takes us to CPC 6, which I believe is Mr. Brock.
And please read.
Hold on, yeah, hold on.
There is a note.
Mr. Lutz.
Sorry about
Yeah, hold on. Oh, yeah. Sorry, just before you get the floor, Mr. Brock. If CPC 6 is adopted, CPC 7 cannot be moved to a line conflict. Mr. Brock, do you want to speak to this?
Actually, it's Mr. Lawton's motion
Sorry, Mr. Lawton.
amendment.
Thank you. So we have raised in the course of our study of C-9, study that has been sadly shortchanged because of Liberal obstruction, that there are grave concerns with a number of sections of this bill, how it will affect civil liberties, how it will affect, in some cases, the very communities that the Liberal government claims it will protect. And there have been several concerns raised specifically about the section on hate symbols. And we will be discussing those more thoroughly when we get to the clause at hand. But if we are to, as a committee and as a parliament, enumerate hate symbols, symbols that have vile meaning, symbols that carry a death toll that often bring up a lot of trauma to various communities, we need to be thorough with it. So I am proposing the following amendment, that Bill C-9 in Clause 4 be amended by adding after line 3 on page 2 the following: B.1, the communist symbol known as the hammer and sickle, or B, by replacing line 5 on page 2 with the following, scribed in paragraph A, B, or B.1, that it is likely to be. So in layman's terms, this is adding the hammer and sickle, the communist insignia, to the list of hate symbols. Communism has a death toll of 100 million people around the world. People have died as a result of dangerous and harmful ideology perpetrated by that. I've had a number of concerns raised by people who have lived under communist rule in Cuba, in Eastern Europe, people who see this as being an incredible evil that needs to be stamped out. The Soviet Union under Joseph Stalin from the 20s to the 50s saw some of the worst mass repression in history and mass killings, from the Great Purge to Gulag forced labor camps, collectivization and terror famine, a death toll in the Soviet Union of up to 27 million. You have in China under Mao Zedong, the Communist Party carrying out massive repression, causing the deaths of tens of millions through executions and labor camps and man-made famines. You have Cambodia under the Khmer Rouge from 75 to 79. One of the worst episodes of mass killing in the history of the 20th century, with up to 2 million people killed, including, that's around 25% of Cambodia's population. So if we are to describe what hate symbols are in law, we need to acknowledge the death toll of the hammer and sickle. So I move this amendment for consideration, that it be added to the list. Thank you.
Thank you, Mr. Lawton. Anybody else? Mr. Barber?
I have to give it to my friend, Mr. Lawton, really. As some committee members have heard by now, I was born in the Soviet Union, and I lived in the Soviet Union until 1989. And frankly, when I look at the hammer and sickle, I'm scared. I appreciate Mr. Housefather's previous amendment, and I appreciate his sentiment, as we both come from the same community, with family who was deeply affected by the Holocaust. But I can tell you that my family has also been significantly affected by communism. And I frankly do not see much of a distinction between the two. The hammer and sickle represented collective oppression. If I could maybe summon my thoughts here, this is definitely interesting. I'm not sure if Mr. Lawton mentioned that it is estimated that subsequent to the World War, more than 20 million Soviet citizens were murdered by the communist regime. And it wasn't just confined to Jews, it was everyday people, Ukrainians, intelligentsia, anyone who had any type of microphone, press members, educators. And so I view it as a hate symbol, and I believe that it is a hate symbol because it drives the extreme of collectivist ideology, where the state says, not my way or the highway, but my way or murder. And I hope that all my friends from around the table will support this amendment. Thank you.
Thank you, Mr. Barber. Any other discussion on that point? No? Okay.
We're going to vote?
Yeah, there's no more? No, we're going to vote. Okay, so we're on,
CPC
okay, Sal, CPC carry, CPC 6 carry, sorry.
On the vote? Yes, so Madame Latenzio? Mr. Housefather?
Against.
Madame Delin? Mr. Chang?
Against.
Mr. Brock?
Yes.
Mr. Barber?
Yes.
Mr. Lawton?
Yes.
Mr. Gill?
Yes.
Mr. Fortin?
No.
Defeated 5-4.
Okay, so
CPC 7.
CPC 7, which is Mr. Brock this time, I believe, yeah.
Oh,
Yeah, CPC 7.
okay, thank you, Chair. Yeah, so the majority, if not all of us at this committee are lawyers. We can all think back to first-year law, when we took statutory interpretation, and the overriding rationale that I remember so long ago, several decades ago, was to always seek clarity when drafting laws. And it's no more important when it comes to the Criminal Code of Canada. In my view, after some almost 2 decades of prosecuting and about 14 years of defending, as the criminal code currently exists, there are so many areas that really require significant editing. So what I bring to the table as a parliamentarian now is the ability to ensure that there are no gray areas when it comes to statute interpretation, that we strive and we look at the criminal code in terms of what's black and what's white. And what is existing right now in C-9, specifically subparagraph 2.2 sub C, as worded, a symbol that so nearly resembles a symbol described in paragraphs A and B that is likely to be confused with that symbol. I don't know what that means. It is so vague. There is no definition section as to what a like symbol would mean. What does likely to be confused with mean? Would that be an objective standard? Would that be a subjective standard? So in terms of the rationale for the amendment that I seek, it's to seek precision, to seek clarity, and to remove that type of language goes a long way. Thank you, Chair. That's my explanation.
Thank you, Mr. Brock. More than anything, you just reminded me how old I am. Mr. Baber, over to you.
I actually remember being taught over breath. It was by a former cabinet Liberal minister, Mr. Bentley, taught me first-year criminal law, and he made the criminal law come to life, for me at least. Of course, as the chair knows, I did not become a criminal attorney, but nonetheless, I appreciate Mr. Brock's input here. So if I just look at the section, and if we could please read it, and if I could please ask my Liberal colleagues to look at subsection C, which is what Mr. Brock's amendment is targeting. A symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be confused with that symbol. So my point is very simple. If it can be confused, then it should not be criminal. I'd like to offer an example. Some folks might say that if you take out the language inside the Canadian Tire triangle, it might resemble a symbol used by the Hamas terrorist organization. They sometimes use a triangle to indicate who the next target ought to be. God forbid. I would say I could probably get around that because that might be incitement to violence, right? Mr. Housefather, ironically, you could probably say that the Hamas triangle is incitement to violence. But I don't want to be watching a Christmas commercial for Canadian Tire thinking that it might be confused with a Hamas triangle. So may I suggest this amendment is really made in good faith to try and not be overbroad. And again, if it is likely to be confused with the actual symbol, then the word confused in and of itself should allow, not only is it confusing, it should allow for some degree of latitude and not be criminal. And also, maybe we ought to think about some first principles. As Labor Minister Bentley would probably say. We're talking about criminal conduct. And we should be very, very clear not to criminalize conduct unless it is clear that it's criminal conduct. Thank you.
Thank you, Mr. Baber. Anybody, Mr. Housefather?
Thank you, Mr. Chair. I appreciate that, and I appreciate these last two conservative amendments, which I think have been made in very good faith. The first one, just to be clear, Mr. Chair, we had no testimony to the effect that the hammer and sickle should be included, and there's a number of others, like the Ku Klux Klan symbol. You know, I think this has to go to thought process to add other symbols rather than just pick one and not another. So that's why I voted against that one. This one, I think, is much more compelling in terms of a discussion about it. My issue is that I think what this is trying to achieve is the opposite. I think what this is trying to achieve is that there is a terrorist group, they have their symbol, and then they manufacture, because they know that the law has prohibited the display of the symbol, they themselves distort the symbol by one tiny iota so they can argue it wasn't the symbol. And the point of, I believe, this section is to capture that. And so I would like to ask the officials who are here, presumably this was drafted by the Department of Justice, can you explain what the intention is of this section?
Please go ahead.
Thank you for the question. And so, yes, confirming that the intention really is to capture symbols that are defined in paragraph A and B. So symbols principally used by or associated with a listed entity, or the Nazi Heckenkreuz or Nazi double sing rune. If there's a slight modification, for example, if the flag of a terrorist entity is a different color background, that if it's displayed for the purpose of promoting hatred against an identifiable group, well, they're not precluded from using that offense to prosecute. So it's really on a technical basis, not excluding symbols that willfully promote hatred.
Sure, and then I'll give the floor to
Just to clarify then, the goal of the way that this is worded by our experts, presumably at the Department of Justice, is not to catch a different symbol that is not included in A and B. It is to take only the symbols in A and B where there is a deliberate attempt to distort that symbol in order to avoid or circumvent the law by the person using that symbol. It is not to catch a symbol inadvertently. Is that correct?
So, sorry, that is correct. It is to capture slight variations, modifications, where otherwise that symbol, it presupposes the definition of the symbols in paragraph A and B. It doesn't create new symbols. Is that helpful? Does that respond to the question?
Yes, thank you very much.
You done, Mr. Housefather?
Yes, thank you. I got my answers.
A little bit so I can see. Thank you, Ms. Breeze, for that explanation. I don't know if it satisfies my concerns. I know that maybe Mr. Housefather is concerned, but the way that you responded to his latter question about the slight modification, did you ever give some consideration to using that language, a slight or some type of modification to an existing symbol, as opposed, which I think is more specific, which as a prosecutor might assist me in making an argument to a judge. If I were a judge, may give me some comfort in knowing that it's a different standard that I'm applying by taking a look at the real symbol, taking a look at the closely resembled symbol to see whether there was a slight modification. I think that language might be better used than the language that so nearly resembles, which I think opens up such a gray area that would there be a prosecution, I can see most cases being dismissed, even on the WD standard that judges would apply in this particular case. It would leave them with a reasonable doubt, not understanding and not appreciating a subjective analysis to that type of symbol versus an objective analysis. So I'm wondering, would you be amenable to tightening up the language to make it a little more specific for prosecutors and to assist judges in adjudicating.
So thank you for the comments. I believe that's really a policy decision, and that's not something I can speak to. With respect to the drafting of this provision, as you pointed out, the objective that you spoke to, using the words nearly resemble in conjunction with, could be confused with, is how the guidance provided in the legislation to narrow down the type of symbols that would be captured. So that was the policy intent and the legal effect of that provision.
Are you done, Mr. Brock?
Yes.
Only Mr.
Yeah.
Barber had his hand up, that's all.
So first to Mr. Housefather's point, I think the real issue here, and this is also to Ms. Breeze, is the intent of the display. You might nearly resemble and not be exactly right, especially if you draw it and you're not good at it, and it'd be slightly off, but if the intent is a terrorist symbol, as we prescribe in this section, then it would be caught and be indeed criminal conduct, right? That's the point I make, is that you don't need to be concerned with the fact that someone made a slight alteration. You could think of an ISIS flag. A very good example is the ISIS flag. There are many variations of it, depending on where you're situated geographically. Some versions of an ISIS flag have more letters than others. At the same time, I think that if you're a law enforcement professional, you look at an ISIS flag and you are probably, and you know if it's an, well, I would hope that you know that it's an ISIS flag or not. So I'm not concerned with not being precise because it goes to intent. Whereas what this section is really doing, I think, is precisely what we're hoping, what this section hopes not to do, which is potentially criminalize behavior by inadvertence. Because what might happen here is you make, if the intent is not there, but to draw something else, then you're now criminalizing non-criminal behavior. I think I'm right on this. Ms. Breeze, what do you think about what I just said?
Please, go ahead.
I think you described well how a symbol is used within the hate propaganda offense, that it is the intent to promote hatred, so the public display the symbol to promote hatred. I would, the reading of the offense, again, it would not expand the type of symbols captured. It would just specify, so that, I guess another way of seeing it would be that police officers on the ground would have to know with great precision that the symbols are caught by paragraph A and B. And if they get that wrong, then they are precluded from, charges or that going forward through prosecution. So that's the inverse, is that the question to the committee would be, do you want that great precision to be on law enforcement? Oh, sorry.
No, it's okay. So to your point, the problem is the word confused. If you listen to what Ms. Breeze just said, and I kindly ask my Liberal colleagues to please bear with me, if I may. The problem is the word confused. What Ms. Breeze is really saying, if you look at the section, if I could just redraft the section, is I would say a symbol that so nearly resembles a symbol described in paragraph A or B, that it is likely to be that symbol. That's what Ms. Breeze is saying the section tries to accomplish. It so nearly resembles that it is meant to be that symbol, as opposed to be confused with that symbol. I'm right on this one.
Thank you, Mr. Bauer. Mr. Brock?
My colleague, Mr. Baber, is very confident in his legal understanding of statute interpretation. So to all the officials that are here, were any of you responsible for this final wording in sub C? Did you draft it? Did anyone draft that?
We did participate in the drafting. Sorry, Mr. Chair, if I may. Yes.
You did participate in the drafting?
Yes, that's one of our roles
Okay.
as Policy Council, is to work with our legislative
Okay.
drafters to put the minister's policy
All right,
into
so-
legislative text.
So circling back to your latter comment about if there were amendments to the language, that would be a policy decision. So are you not policy decision makers at the Department of Justice, or are you just responsible for drafting legislation?
We provide advice to the minister, who gives policy direction, and then we put that into play.
Okay, so what was the genesis then of that particular clause? Did you consult with legal stakeholders? Did you consult with judiciary? Did you consult with academics, law professors, anything like that? Did it come from specific ethnic minorities? Were you persuaded one way or the other in terms of the language to be used? I'd be very interested in your response.
I can speak to this one again. And I understand the concern is specifically targeted to this particular provision. This was a provision that was developed, as Ms. Breeze said, to try to close what was thought to be a risk of a loophole that could be created in the offense. Generally, we don't consult on the specific wording in a type of offense like this, although I know there were broad consultations on the broader policy objective of Bill C-9.
So what real-world examples can you give me that would support the inclusion of this clause that came from law enforcement saying we are missing an important tool in our toolbox to tackle individuals who are demonstrating on our streets, harassing religious members of communities, where they're demonstrating and they're using symbols, but we don't know whether it's an exact replica of something that is within the regs or whether there's been a slight modification. Did you get specific input, and do you have examples of cases where police officers were presented, should I or shouldn't I charge? And if they said, I can't charge because I'm missing a tool in my toolbox, is this designed to remedy that?
So thank you for the question. In terms of hearing feedback, generally feedback we have received is that police officers are looking for clear tools to address this type of conduct. A red line as to what type of symbols, for example, could be captured by this type of offense. In terms of examples of how this could materialize, again, if we take the Hezbollah flag or Hamas flag and say it were the background color were changed, and then that flag was being waved in a public place, and the person waving it was also chanting slogans that directly targeted an identifiable group. So
But
if
wouldn't there
every
be,
element-
wouldn't there be criminal laws already in the books to address that particular example you just gave? An incitement to hatred?
So there, perhaps I could just finish this one first. So if there's a more limited definition of the symbols to A and B, then this offense would be precluded. However, to your point, there are other tools in the criminal code, other hate propaganda offenses that could potentially apply depending on the case at hand. Communicated statements for the purpose of 319 offenses include visible representations and signs.
See, here's the problem. and what I'm about to say to you right now is certainly not new to you, because if you've been following debate in the House, if you've been following debate here in this particular committee, we would love to completely reject every aspect of Bill C-9. It is a flawed piece of legislation. Because there are existing laws already that deal with the multitude of disturbances that we have seen over the last 2 years. So it's not an issue of a want of criminal legislation, specific tools for law enforcement. There's a lack of will from law enforcement. I have gone on a tour. I'm still touring across the country, talking to stakeholders. I'm absolutely just surprised and stunned at the number of examples of lawlessness on the streets where police have been directly told by their municipal leaders to abandon their number one sworn responsibility, that is to uphold our laws, to enforce our laws, and simply to be peacekeepers. And I'm not going to identify the city because I'm not going to out the police service, but I had spoken to a number of Jewish leaders in this particular community, and they explained to me example after example after example of protesters, pro-Palestinian, pro-Hamas protesters, specifically spitting on Jewish individuals who simply wanted to attend their synagogue, right in the presence of police officers. That's intimidation, that's assault. They've got the tools. They're not enforcing. So I really, and I appreciate your explanation. You've given me some hope that you have done your due diligence, and I would never accuse you of not exercising due diligence. This is a touchy area, but I'm just concerned that the police asking for more and more provisions to deal with thorny issues may not ultimately achieve what you're hoping to achieve, what this Liberal government hopes to achieve when we have a lack of will to enforce. The fact that we had demonstrations lasting 2 years in our country is absolutely pathetic, and it put this country in a real difficult position on the world stage. I've read and watched news reports from all over the world, and the ability for government leaders and law enforcement to take immediate concrete steps to deal with this lawlessness is something this country did not do, and it's shameful. And I'm disgusted as being a former member of the legal community that this happened in my country. So that's what I'm concerned about. If you give a provision, a new tool to law enforcement that I think is still wrought with confusion, is it up to police now to determine whether or not this is clearly in line with a symbol that falls within the regulation, or something that closely resembles and that is confusing? I can see so many red flags in the mind of a young police officer, and despite leadership saying we want this, I don't think it's going to have the desired impact. All the more reason, in my view, to always seek clarity and precision and to strive for black and white language when we're dealing with anything in the Criminal Code of Canada. And I appreciate all of your responses, but I'm still not satisfied this is going to address the issues that present itself. Thank you, Chair.
Thank you, Mr. Brock. I've got Mr. Lawton and then Ms. Latanzio.
Thank you. So to the officials, we know that, I want to, excuse me, I want to make this less abstract for the time being, because we know in the context of the last 2 years, there have been a number of protests on Middle Eastern politics in communities across the country. Let's say a listed terrorist entity claims as a symbol the keffiyeh, and this becomes a symbol that's very associated with a listed entity. Would a keffiyeh be viewed, or could it be viewed under this legislation as a hate symbol?
So thank you for your question. Taking a step back, we'd have to look back on, it's always a factual analysis, correct? And so the test here established in the provision would be, is it principally used or associated with? And so that would be, again, showing there had to be a close nexus between the group, the listed group, and the symbol. I can't provide a response as to yes or no whether that symbol would be associated. It really is a determination, again, for law enforcement based on available evidence, and I think that's as far as I can take it.
But by your answer, you're now saying that there would be a gray area where that could be. Because you can't say no, you're basically saying that a keffiyeh could be under this hate symbol if there was a listed entity that had associated itself with that symbol.
So if, based on available evidence, the facts at hand, it would be demonstrated that that symbol is principally used by and associated with the listed entity, and that's only a determination that can be made by law enforcement and prosecutors after a full investigation. Perhaps, but it's not a symbol. I cannot say today whether factually that is principally used by or associated with a listed entity. That nexus is a factual determination.
Iran has been acknowledged as a state sponsor of terror. Could waving an Iranian flag attract the same scrutiny? Could it be viewed as a hate symbol? Sorry, that was to the officials.
Can you repeat the question? Sorry.
Yeah, so Iran has been acknowledged as a state sponsor of terror. Could an Iranian flag be captured by this definition as a hate symbol?
So Iran is not a listed entity under the terrorism listing regime, under the criminal code.
So when we talk about like symbols, and I realize we are discussing one particular amendment here, but we have to look at various points C-9 in its totality. So if you'll indulge me, Chair, I do have to ask about other parts of the bill here, such as
Can I just
attorney.
interrupt you for 1 sec? There's a lot of conversations going on around the room, so I'm having trouble hearing Mr. Lawton and the witness, so if people don't mind. Go ahead, Mr. Lawton, sorry.
Just come back.
So, sorry, we have to look at other aspects of Bill C-9 here, in particular the removal or potential removal of Attorney General consent for laying charges. And the reason I bring that up is because you in your previous answer, Ms. Breeze, mentioned law enforcement discretion as being a key part of this. So how do we, and if this falls outside of what the Department of Justice is able to comment on, I understand, but how do we expect law enforcement to make these calls? Sometimes this comes down to, as Mr. Baber alluded to, nuances in the Arabic language that might not be known. Sometimes it comes down to, very technical details. In some cases, there is complexity to what is on the list of terror entities in the first place. So I'm just wondering if you could explain how these things would intersect with this section, and with that in mind, why we're talking about trying to remove ambiguity here.
Thank you for the question. So caveating, this is not my expertise. I'm not in law enforcement. But we would assume that police have tools. They have training to be able to identify. You have special counterterrorism units, for example. And so there are tools, even publicly available, databases of symbols. So again, relying on that expertise of the police, their tools, their knowledge, this is how that factual determination would be made. And I would also like to always bring it back to whatever the symbol is. If you've established that the symbol meets the definition in the offense. Again, it all has to be considered within the broader offense. Again, the willful promotion of hatred against an identifiable group.
So we heard testimony from, I can't recall her names precisely, but it was a lawyer with the Canadian Civil Liberties Association, in which she posited that this section, unamended, basically amounts to a strict liability offense, where the act of displaying the symbol itself, irrespective of motive, is going to be an offense. And I just wanted, for clarity here, I'll read the section in question here. We are talking about page 2, lines, so page 1. Everyone commits an offense who willfully promotes hatred against any identifiable group by displaying in any public place. Now, the Canadian Civil Liberties Association's position on this was that the wording of this suggests that by displaying, that is in and of itself sufficient to say that hatred is being willfully promoted. What is your view on that?
Thanks for the question. I would respectfully disagree. I think it's quite clear that this offense, which, as you will see how it's structured, resembles the existing willful promotion offense. The display of the symbol, it's to be understood within the broader context of someone who is intentionally, willfully promoting hatred against an identifiable group by displaying the symbol. That displaying of the symbol is the communication. So it is not a straight ban on symbols, nor is it criminalizing the mere display of symbols.
My last question, did you or anyone in your department advise the government for or against the section that Mr. Brock's amendment seeks to remove, specifically the wording of resembles a symbol? Did you advise for or against that in your counsel to the minister?
So our role is always to advise the minister on the criminal law and Bill C-9 as it goes through the parliamentary process. And so within that ambit, we continue to provide advice on all matters related to the bill.
So, sorry, are you claiming or disclaiming responsibility for that wording? You can blame the minister. I won't hold it against you.
What I will say, what I will say is that our role is to provide advice to the minister on issues related to criminal law. The content of that advice is subject to solicitor-client privilege, and so we're not able to be more specific in communicating the advice that we do or do not give.
You are paid by Canadian taxpayers, correct?
We are.
Okay. Thank you. Yeah.
Thank you. Ms. Latanzio?
Yeah, Mr. Chair. We heard testimony here at committee, including the Edmonton Police Service, and I just want to put it on record just so that it's clear for everybody. And I looked up their testimony when they came before us and their take on this whole issue of symbols. So, and I quote, "The EPS also supports the additional offense of willful promotion of hatred against an identifiable group by displaying certain specific symbols like the swastika, the SS bolt, or symbols of listed terrorist entities. This section clarifies these types of symbols, but also reiterates the requirement that police establish that a suspect was willfully promoting hatred against an identifiable group in public." So I just want that to be on the record, that the Edmonton police force was very much in favor of this whole section in terms of symbols. That's it. Thank you.
Thank you, Ms. Latanzio. Anybody else on this, on Mr. Brock's CPC 7? No? Okay, so shall CPC 7 carry?
Madame Latanzio,
Against.
Monsieur Housefather, Madame Dillon,
No.
Mr. Chang,
No.
Mr. Brock,
Yes.
Mr. Baber,
Yes.
Mr. Gill,
Yes.
Mr. Lawton,
Yes.
Mr. Fortin.
No.
Defeated 5-4.
Okay. Thank you. Defeated. Okay, so now we are moving. Yeah, Mr. Faber?
Thank you, Mr. Chair. I'd like to move an amendment to the same section, specifically amending Clause 4 on page 2 line 6 only by deleting the words confused with that symbol and substituting the words a symbol described in A or B.
Can you read out the whole section, the amended
Yeah,
section?
so the amended section will be a symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be a symbol described in A or B.
Okay. Does everybody understand that? Mr. Fortin?
No,
Translate.
I agree.
Chair, can we just have it done in French and in English so that everybody can appreciate the amendment on the floor?
Okay, so what do
Point of
we,
order.
sorry, was it Mr. Lawton?
Sorry, I don't believe that Ms. Latanzio heard Monsieur Fortin, but he said he agrees with it. So I believe he understands it.
All right, well, she's entitled to make the request.
No, I know,
on
I
her own
just
behalf.
didn't believe she heard that, Chair. That was,
Okay,
yeah.
fair enough, okay.
So,
Okay.
Mr. Chair, can we just have it suspend for a couple of minutes?
I was just going to say, why don't we suspend for a moment, yeah.
So, one second. We don't need to, I would propose not to suspend if there is a will on the part of the committee to stand my amendment down and to come back to it. It just, I'm in for a technical problem in that once we move past this clause, I'm unable to, which is why the time is urgent, but I don't want to hold up the committee.
Why don't we just suspend for a few minutes just to clarify this, and we'll come back.
Okay.
All right, so suspended. perhaps, yes,
Could I please ask the clerk to read? We had a further revised change to the initially proposed amendment, so the amendment has been unofficially amended. If you could please hear the new version and also in French.
you took the words right out of my mouth.
Thank you.
Thank you, Mr. Chair. I will read the paragraph C. A symbol that so nearly resemble a symbol described in paragraph A or B that it is likely to be a symbol described in paragraph A or B. In French, en français, ça fait un symbole à ce point semblable.
A symbol similar to those described at paragraph A or B, similar to one of those symbols described in paragraphs A or B.
I appreciate an opportunity to weigh into this, and I appreciate the fact that the committee is entertaining this amendment at this time. I am very concerned with the voting down of the Bloc amendment that Clause C will remain in its present form and will therefore criminalize, should this legislation pass, a symbol that so nearly resembles a criminal symbol that it is likely to be confused with that symbol. What that will do is it will confuse law enforcement, confuse lawyers, and also potentially get someone who did not mean to display a symbol referred to in paragraph A or B, but did so, and that depiction was confused with the symbol in A and B, and you have a otherwise innocent person charged with a criminal offense. I am mindful of the fact that, you know, intent probably factors into this a little bit, so there may be some grace, but if I may, I referred to the previous Liberal minister who taught me criminal law. I'm reminded of Professor Graham at the University of Western Ontario, one of the leading jurists in our country on statutory interpretation. And I remember first week of school, first week of statutory interpretation, he told us about the mushroom case. And I apologize that I'm unable to cite the name of the case, but the proposition was simple. He asked, is mushroom a vegetable? And he said, well, look, I have a lot of experience ordering vegetarian pizza, and when I want a veggie pizza, I get mushrooms on it, so I would think that mushrooms are a vegetable. Well, the issue became prevalent vis-a-vis the question of whether mushroom growers ought to be paid minimum wage. And the case turned on the fact that if they are vegetable growers, then employers would be exempt from paying minimum wage as prescribed for vegetable growers. And if they're not vegetable growers, then there would be a mandate to pay them minimum wage. Mr. Housefather seems to think he might recall what I'm referring to. And so the case turned on the fact, the statutory interpretation turned on the fact that, well, we know that mushrooms are not really vegetable, they're fungi. But mushrooms were grown inside greenhouses as opposed to, you know, outdoors, because those were commercial mushrooms. And as a result, the court asked, what is the intention behind the legislation? And that is, well, sometimes due to weather elements or the industrial carbon tax, the cost of mushrooms might be very prohibitive. But when you have all sorts of weather events, you might lose your crop. And so growers would be given some latitude not to pay minimum wage. However, because mushrooms are grown in greenhouses, then the grower doesn't have that problem. The mushrooms are not subjected to the elements. And as a result, the annual crop would come in, and the grower would sell his mushrooms. And so there would be no need to exempt the mushroom grower from the application of the minimum wage. And so the question is, are mushrooms vegetables? The answer was, look at the intent of the legislation. The intent of the legislation is to exempt those that are risking losing their crops. The mushroom grower will not, because it's in a greenhouse, and as such, there is no need to exempt them from the application of the minimum wage, and not even answer the question of whether mushrooms are vegetables. So in that spirit, I appreciate the latitude and the accommodation. I think it's very important that the intent of this legislation is clear. We, conservatives, tend to err on the side of caution, not only when we talk about moving issues that might be transformational without thinking it through, but we want to be very conservative in the application of criminal law because we preserve charter values, we preserve the presumption of innocence, and we certainly don't want a law that would be overbroad. As presently outlined, the law might criminalize conduct that it doesn't mean to criminalize. That is why my proposal that the conduct that the symbol displayed need to be so nearly resembling a symbol in paragraph A or B that it is likely to be the actual symbol referred to in A and B eliminates that ambiguity and therefore I think accomplishes what this section intends to accomplish. I'm grateful to everyone on this committee for entertaining this seemingly small change. I think it might actually save law enforcement a lot of time, but deny criminal lawyers an ability to argue the statutory interpretation of what this committee has otherwise intended. Thank you.
Sorry, apparently there was a slight modification to the translation.
Merci, Monsieur le Président. Simplement, je vais relire la...
Mr. Speaker, I'm going to reread the French version. We just got the translation. A symbol, so similar to a symbol mentioned in paragraphs 1 and 2, to be confused.
Okay. We're good with that? Okay. Mr. Lawton, did you have your hand up?
Yes.
Yeah.
So just for context here, and I appreciate my lesson in statutory interpretation from my colleague, Mr. Baber. I've learned a lot, and I'm now hungry. The amendment, I think, look, it doesn't go as far as the original amendment, but the committee decided to vote against Mr. Brock's approach, and that's the way the mushroom bounces or something. But I do want to ask our officials, with the further amendment that's been put on the table, does this ameliorate your concerns that you raised in respect to the first attempt at this from Mr. Brock? No, ameliorate, mitigate. No, ameliorate.
Ameliorate.
I heard right.
We need
Alleviate is
statutory
actually the right word.
interpretation.
Ameliorate. Concern.
See, we're all learning things today.
So I want to be helpful. When I spoke earlier, I was pointing to the policy intent and the purpose, mindful that I can't provide advice on this amendment. Is there a specific question with respect to?
I'll rephrase it. Do you believe that the amendment that has been put forward by Mr. Baber keeps with the spirit of the policy in that section of the bill?
My mic is on. Again, I think that puts us in a bit of a difficult position to be able to respond directly to your question. It is certainly if it's up to if the committee thinks that that amendment is consistent with the policy intent of the bill, then we would invite you to proceed with your meeting. I think we were clear, and Ms. Breeze was clear as to the original policy intent of the language. This would maybe narrow it slightly, but the provision would remain on the books to provide maybe some support to Crown prosecutors and police who are looking for guidance on what symbols would fall under the offense.
Okay, I don't want to do the thing that I'm sure frustrates people. So what you're saying is, because I legitimately do not want to put words in your mouth, but would you view this amendment as diverging from the policy intention and the legislative goal of the section as it is? Because that's really what I'm asking here, is do you believe that this amendment is fundamentally altering the policy direction? So do you think this is a divergence from the intention that you and or the Minister of Justice had when drafting this section?
Again, trying to be helpful, I think the question is it the committee's intent that it change the policy which the department has shared at the outset?
Sorry, I don't mean to cut you off. I'm trying to not put you into that realm. I'm trying to ask, let's go back to first principles here. What is the policy intention of that particular section?
This was your...
What is the direction that your department was given that led to that?
Perhaps what I can do is just speak to technically what this amendment would do, as opposed to the policy intent behind the amendment that is being proposed.
Sure, sure.
So if I were to read, for example, described A or B, that is a symbol, that is likely to be a symbol as described in A or B, I believe is, did I get that correctly?
Yes, that is likely to be a symbol as described in A and B.
So is likely to be a symbol in A and B would, at first glance, appear to mean the symbol described in A or B.
Mm-hmm.
So there's not, une marge de différence, I don't know how to say, between C. So you're basically, C would capture a symbol that resembles, that is a symbol that resembles A and B, and that is likely to be A and B. So again, there's not much difference, I would say, between A, B, and C. That's plain reading.
Realizing you are not in law enforcement, but if this were to come before a courtroom that you were working in, would you view this as being an amendment that provides greater clarity in how to interpret that offense?
I think I'm delving beyond my role as a technical expert in that type of question. What I can speak to, again, is the technical aspects, which I've just done. And if that is the committee's desired intent, interpretation, then I think that the committee would be best able to respond to whether that empowers law enforcement to better understand the provision.
Okay. Thank you.
Okay, Mr. Lawton, you're done? Mr. Brock?
I'm moving a sub-amendment to my colleague, Mr. Baber's amendment. I do this not out of disrespect to Mr. Baber. We're trying to come up with a solution here that will satisfy everyone at this particular committee and also addresses the overall concerns that I had at the outset in terms of my original amendment that was voted down. And I also appreciate the input from both Ms. Wells and Ms. Breeze. And I hope you are not concerned about us questioning you. I appreciate you can't give us legal advice. You can't provide us with a legal opinion. You are here to help. But what I'm picking up when I read between the lines is some degree of hesitation. I don't think you would support or not support a potential amendment. It's to the will of the committee. So I think there is a compromise here, and I wish everybody would pay attention and to hear me out on this. I propose that we take the existing language in sub C to now read a symbol that so nearly resembles a symbol described in paragraph A or B, period. No further explanation beyond that. And I think that provides a very clear direction to law enforcement. We still get into interpretation issues if this were a trial in terms of a subjective or objective analysis, but we don't have to worry about that. That's for a different day and a different discussion. But I think it clarifies your concerns, Ms. Breeze, that the amendment brought by Mr. Baber may be more confusing than clearer. So that would be my sub-amendment, and I don't have it drafted, but I can certainly do that when the bells are ringing. I understand that we are not providing unanimous consent. I think there's a will of both the Liberal team and the Conservative team to actually attend back at the House for the purposes of voting, and in the interim, I can actually draft this in both official languages.
I think you're doing the opposite of what you want to do with your amendment.
Mr. Housefather?
I
Suppose that is not a sub-amendment that would be receivable on Mr. Baber's motion, which substituted words. Now you'd be cutting off the entire sentence that Mr. Baber had substituted. So I don't believe that's a proper sub-amendment on Mr. Baber's motion. I'd ask you to rule that way, Chair. I'm right on that.
All right.
Technically speaking, with
Okay, so the bells are ringing. Yeah, the bells are ringing, so we are going to suspend. Hopefully somebody's going to listen to me here. Mr. Baber, please. The bells are ringing, we're going to suspend. I think I have a solution that I might get us through this, which we can do during the break, but so we'll suspend till after the votes and ask everybody to be here 15 minutes after the last vote. Okay, meeting suspended.
The tally of the vote is declared.
Not after the last vote, after
Well,
the
if you want
tally.
to get out of your chair, before it's, that's fine, yeah, go ahead. By all means. All right, meeting suspended.